Good morning and good afternoon, everyone. We're just going to go ahead and get started. And with the midterm elections behind us and a divided government, movement on a federal privacy bill has been stalled. Hopefully, it's moving forward. We'll see. That leaves states and other jurisdictions to fill the vacuum with their own privacy laws, and that movement continues. In 2023, at least 5 states will have comprehensive privacy laws with regulations in numerous other states moving through the legislative process. And that's in addition to other privacy activity across the globe. Building a successful privacy program requires the right balance of processes and people, including the right privacy platform that meets the needs of each organization in its particular industry. At the same time, it's more important than ever for organizations to have a solid privacy training program in place for both legal and reputational reasons. And with rapidly changing privacy landscape, how do you build a successful privacy program and put a baseline training in place that can stay relevant for an extended period of time? So that's what we're going to be focusing on today. And now I'd like to introduce our 2 speakers. Our guest today is Dan Solove, who is the John Marshall Harlan Research Professor of Law at the George Washington University Law School. He is also the founder of Teach Privacy, a company that provides privacy and data security training to businesses, schools, healthcare institutions, and other organizations. And with him is Leila Golchehreh, the co-founder and co-CEO of Relyance AI, a machine learning-based privacy platform rethinking data protection, and a former data protection officer and privacy counsel to Workday, DataDriven Insights, and dozens of companies in the tech, healthcare, and autonomous vehicles industries. So to kick off the discussion, let's start with the basics. Leila, how do you begin building a privacy program, and how do you think about it if you're starting from scratch?
Sure. Well, thanks, Jeff, and great to see you again, Dan. I was enjoying our travel discussion just a minute earlier here, and happy to have you here today. So it's a really big question, Jeff. I think, and I think it also depends on the maturity of a program and a company as well. So there are some companies that just don't have anything in place. And I think at that point, and even when a company actually does have a more mature program, it's very critical to build relationships with key stakeholders across the organization. Take your CISO out to coffee, get to know your VP of engineering, get to know your executive leadership team, and make sure that you're emphasizing the critical importance of data privacy across the business. And, a lot of this is really focused on education. So thrilled to have Dan here to talk about that, because you have to have cross-functional stakeholder buy-in. People need to understand what's going on in the privacy landscape in order to get them to prioritize it as one of the program's initiatives. And whether the program is large or small, or you're just starting from scratch, one of the most foundational questions to ask is, what are you doing as an organization? What are the key products that you're building, features that you're building, and what are the types of processing that you're taking into account? And then, of course, with all the new developments, especially here in California, with the GPC, or Global Privacy Control, if you're not familiar. We also have employee data now subject to the CCPA amended by the CPRA going into effect in January. Some huge developments that can just be really difficult to stay on top of. So making sure that you also jurisdictionally have awareness, understand which laws your organization is subject to, so that you can build a program that's really reflective of that is critical. And then once sort of these foundations are in place, really knowing your data, understanding what data you have, who's accessing that data, and generally what is being done to that data. Absolutely critical foundational questions to building any privacy program. So there's probably a PhD thesis we could write on this, but I think Dan is going to have a lot to share on the privacy training, which is, it can be really difficult to roll out, right? And especially create from scratch. So Dan, would love to get your thoughts, and I'll pass it over to you to share a little bit about training.
Sure, absolutely. So training is obviously, I think it's a very important component of a program. One challenge with it is that privacy is such a complicated landscape. We have just so many laws out there, so many intricate parts to what must be done for privacy, and so much change in the landscape. So it's very complex and also very dynamic. It's very important to make various folks at the organization understand both why it matters and also what they need to do, and to really have a good grasp of the issues, or a good grasp enough so that they know when to ask for help, when to consult with the privacy office. And so training has a bunch of goals. General awareness, just making everybody aware of the importance of privacy, what they need to do. Then there's also, I think, an important component to just understanding what laws they need to comply with, and what those requirements are. Training can kind of go above that in some ways to try to look at the common denominator to laws and certain basic things for compliance that will get you to satisfy a number of laws, such as data minimization and other basic data privacy principles. But then on top of that, there are specific laws that have specific terminology and very specific rules, such as the CCPA, the GDPR. If you're subject to HIPAA, there are very specific things you need to do for those laws. And so groups that are dealing with those laws do need to understand the specifics when it comes to those laws. So training really involves all of those pieces. So it's actually, I think, multiple pieces to have a successful training program. And obviously it depends a lot on, what a particular company or organization is doing, which laws is it triggering, and then, how big is it? And that really shapes, what the trainings should look like.
Yeah, and I think that's one of the big challenges, absolutely, Dan, is just identifying which laws that the organization is subject to, because there is some sort of controversy around it. It's sometimes, where's the data subject base, where's the company base, where's the processing happening? So a lot of sort of foundational questions to consider. And I would add that, some companies have taken generally the approach of, we need to have a baseline of almost just principles, because sometimes complying with one law means violating another. So figuring out a way to conceptually and getting that sort of philosophical alignment for compliance is definitely one of the key focus areas. Is the organization going to baseline itself on GDPR? Because it's one of the most comprehensive privacy laws that exists, but that might prevent that organization from, sending out marketing emails, which it can do here in the US. So philosophically getting that alignment, which is a conversation that needs to be had with the business. And then to your point, Dan, as soon as you have that understanding of the applicable laws, or those laws that you're going to do your best to comply with. And by the way, even if you do take that approach, never kind of conceding or admitting that you are subject to those laws. But for example, if you get a data subject request, someone trying to delete their data, just generally recognizing that as a principle, you are willing to comply with that request. And getting that understanding across your business, then you can decide how you train up the organization, and also making it sort of fun, right? Because privacy is really kind of it can feel like a heavy topic. That's one of the reasons that I've always loved your trainings, Dan, because they're just fun, they're lighter, and it gets principles across. So it lighter in the respect that it's they're enjoyable, and I think that's really one of the key areas that Privacy Council need to focus on, right? You have to make it that it doesn't feel like a chore, because it is a heavy lift implementing a privacy program, even if you're coming in to a mature program. If you're implementing GPC, or if you have to now have employees subject to new laws, employee data that might be subjected to those new laws. It's really important that you kind of try to bring levity to the situation, even if these are heavy topics. That's one of the things I've always loved about your trainings, Dan.
Well, thanks so much. Yeah, and I agree with everything you've said generally. When building a privacy program too, the training is a piece of the larger program, and there are the folks that are involved in the program, designing the program. There are things that they might need to learn too. There's also folks that are dealing directly with data subject requests, or directly with other forms of data very heavily, and they'll need a different kind of training than just the general workforce.
Yeah.
And so I think one thing with training is that not everyone needs to be an expert on privacy law. And so, it has to understand that, for most employees, the really important thing is knowing when to ask for help, when an issue arises, what basic things they need to do. And I think it's very important to teach people, why should they care? Because if people don't care, if they don't understand why any of this matters, then it just becomes a kind of a bureaucratic exercise, and it just they're not going to be motivated to want to do anything. So I think it needs to talk about why is this important, and then another key component is just how do we understand personal data. The concept is actually very complicated because it's a moving target. A lot of data can be personal depending on how identifiable it is, and that depends on what other data an organization has, or how readily certain things can be re-identified in certain cases. And so I think people need to understand that it's not so easy. And it's, I think, better to err on the side of thinking that certain data could be personal data, rather than to rule it out and then you are not doing something with data that would ultimately be subject to privacy laws. So I think understanding that is really key. And then obviously, I think what helps a lot is the general principles, and under all the privacy laws, and I've looked at privacy laws around the world, they do have a lot of things in common. They actually have a lot of common ground. Most laws require data minimization. Most laws require some form of notice before collection, specifying the purposes of gathering the data before collecting it, making sure that data is used for those purposes and not for other purposes without people's consent, being certain restrictions on how the data could be shared or transferred to others. Different laws have looser or stricter controls on that, but typically there are some restrictions on what can be done with data once it is gathered. There are general requirements of confidentiality in privacy laws. You can't just take the data and just post it to the world. So I think these things are some basic common ground things that apply across the board to all privacy laws, or the vast majority of them. And so we can cover that ground and why privacy matters, and just generally an understanding of personal data. And that goes to everybody. But the complicating thing then is, well, the specific laws. And those will typically be targeted to specific practices or specific things that specific people at an organization are going to do. And for those, I think more targeted training is needed. But I think generally, a big thing about training is just getting people to care, and then also helping people know when they should ask for help. Because ultimately, too, I think that people are not going to remember exactly what sensitive data is and all the things that each law says are sensitive data. They're not going to remember all the intricacies of all the laws, but they need to know enough to know that certain things might be sensitive data. They should ask before they just start doing things. I think that's the most important thing about training, is that people need to know enough to know that there are a lot of times they should be asking for help. They should be asking questions. They should be engaging the privacy office, because that's really key. The privacy office and a privacy program can't really work if there isn't buy-in by the various groups at an organization. And if they're not cooperating and seeking help and advice and telling the privacy office of, here are the issues I'm encountering, here is the data I'm gathering, it's almost impossible to administer a privacy program if there are these kind of dark parts in the organization that aren't communicating with you.
Sure.
So I think it's really key that they understand, why they should engage privacy, why they should be asking questions, and that there are a number of times where they should be reaching out to privacy for some guidance before they just start doing things. And when you look
100%.
at where things go wrong at companies, it's where people start doing things and then they don't realize they've triggered a privacy law, or they've done something that's in violation of a privacy law, and they're not even aware that this is a problem.
100%. And, I think that your point that you made, Dan, on the effective principles that apply across many different laws is absolutely key. And lots more to say on that. I think you're going to ask us a question though, Jeff.
Yeah, I think we covered some of it, but I would love to, redirect back to, we talked about building a privacy program from scratch, but I'd love to talk more about, what if you have a mature privacy program? Is there still work that needs to be done to further develop the program? And, what can you do to take it to the next level? And I wanted to direct that to Leila first, and then we'll to Dan after that.
Yeah, I think so. I agree with everything Dan just said, and I think just generally to kind of just piggyback on the comment about principles across different laws and having sort of a global training for the whole company, and then more specialized training for those people that might be handling data either subject to different laws or that is more sensitive, with that clear definition of personal data. Really key foundational questions to answer. So a number of times I've had clients that had very mature privacy programs. I would take it back to some of the key things that I think are really important. First, building those relationships across the business. I can't emphasize enough that the importance of doing so. I mean, really go get to know what people are doing, because they will feel more comfortable opening up to you as counsel. It can feel kind of scary sometimes for other members of the business when a lawyer is asking them a bunch of questions about how they're handling data. So you just want to take that away. When you have a personal relationship, people are more willing to be open and talk with you about what's really going on. And then, taking it again back to some of these foundational principles, right? We have to operate with first principles when we have so many laws that are developed across the world right now. Really understanding, what data you have, who's accessing that data, and what is being done to that data. Fundamental questions. Now, if you're coming into an organization like I previously had, where the business might be operating for a decade, 2 decades, 3 decades, or even longer, and you have to familiarize yourself with data processing. If you're mandated to understand the program and build privacy around it, if you've got code repo upon code repo, it's kind of like, how do you get that visibility into what's actually going on? I think part of it is, having those conversations, surely, because even when you bring a privacy platform like, Relyance that can help with this, you still need to have those relationships. You still need people to feel like, they can be open with telling you things about new products that are coming down the pipeline. But it's very critical to get an understanding of the existing products and services that your organization is offering. And then particularly when you're serving in the data controller capacity and you are sending out marketing emails, or you're processing employee data, or you're receiving job candidate data. These are all other areas of focus for the business. And keep your eye on not only what are the underlying technology products and services that might be being built, but also from a data controller perspective, when we're processing information from the perspective of job candidates, HR data, it's very important that we also have visibility on what's going on. What are the data retention practices? And Dan laid out some of the really foundational principles that are important for organizations to consider. I think that will certainly continue to be true, particularly in 2023, when we have so many new changes going into effect. So again, I think all of these questions, Jeff, could be a PhD thesis, but I'll stop there because I'm sure Dan has more to add.
Yeah, I mean, I think you said it very well and captured the real key points there. On the training front, I think it really starts with the organization just getting started is just wants to get to something out there, something basic to say this is our program, this is what we have. As time goes on and a program becomes mature, I think then the task is keeping current with this very complex landscape of privacy laws. It really is immensely complicated, and it becomes more complicated as more jurisdictions around the world pass privacy laws, as the states pass privacy laws. The direction has been to more complexity, more different laws. There are all sorts of differences in the scope of coverage of the laws, in how they define personal data and how they define sensitive data, in the various rules that they require for things. So part of it is the challenge is just kind of understanding each of these laws and kind of where they are similar and where they aren't. How do you strategize compliance? Because you have to, it's hard to do 20 different things. So you need to pick one approach or a few approaches to address a number of the laws. And the more you can kind of do with, something simpler, better. And with training, you can't train someone in 21 different definitions of personal data. You overload them with too much information. So you have to, be strategic on what you train different people on and what you want them to focus on. And I think on the mature program, at that point, you have the luxury of starting to think about, okay, what will really benefit this particular group of folks? So you can look at the engineers. What should they really know? What should we teach them? I think their, understanding privacy by design is really important. And so education can be pushed out around that. They can learn, some things that would just help them flag issues that ultimately they would then engage the privacy office in helping them with. And folks involved in marketing should be, taught about the marketing laws and some of the rules there. So a lot of the more mature programs is really thinking about, what different roles there are in the organization, what different groups of people need to know, when do you want them to engage the privacy office? What kind of advice will you give them, and really thinking through, the complex landscape and then mapping it on to your organization. And then, what kind of education do you want to give people in these different areas? Because not everybody needs to know everything. And it's too complicated to teach everybody everything. So I think the more mature programs is really then figuring all that out. And then strategizing on, how do you comply in this, ever-changing complex landscape.
Yeah, I think that makes a lot of sense. And, I think making it fun, like Leila said, is also important, because we all have lots of training programs that we have to go through, and making them more interesting is always a good thing. Well, let's dive a little deeper. Leila, you've held in-house chief privacy officer positions before you started Relyance. Maybe you could talk a little bit about, kind of what worked and what could have been improved with the privacy programs you've seen.
Yeah, I think foundationally, you have to make sure you have executive buy-in. That's so critical. You have to feel supported with your program. And I think that privacy counsel and privacy and security professionals have a really hard job. A lot of the business models and technology companies are to do as much as they can with personal data as possible. And so really ensuring that you have an executive team that's supporting you is absolutely critical. And, as we talked about relationship building, I think that is one of the really critical relationships to build. There are companies where privacy is part of the business model, so the executive team really gets it. And then others where this might be a sort of tangential area of focus for the business. And so it's up to the professional, which, it's not really taught in law school, but should be. Maybe we do a training on that together, Dan, on, getting buy-in for a program when it's not specifically part of the business model, and really learning to justify that. And there are a number of ways of doing that I found successful. So I think first and foremost, executive teams and boards are really driven by data. So really establishing from a data-driven perspective, these are the reasons why privacy matters, and these are the ways in which we can help to address that. Making sure to secure budget for the program so that you can invest in things like training, like getting privacy platforms and tools, like getting outside counsel when there are some sticky issues. It's very critical that you have that executive buy-in and support for your program. And if you don't have it, that's something that you should be focusing your time on. Because unless and until the executive team is supporting you, it can be a very, very difficult and uphill battle. So you want to try to, and this is for people really fighting the good fight, in-house and really trying to do the right thing with personal data. So that's something, if ever there's anything that we can help with for anyone listening, I'm always happy to talk through that in more detail. But I think in addition to that, it's the executive buy-in. And then it's the observability. It can be impossible if you are sort of flying blind and you don't have observability in what's being done with data, or if there are new products and features being launched and you're the last one to know about it. This is a problem. You've really got to get into those sprint planning meetings, get into product and feature planning meetings, understand exactly what is coming down the pipeline and get ahead of it. And, Dan mentioned a privacy by design training. I think that's right on point. We have got to design privacy into the way that we are thinking about new technology products, new features, and any kind of new personal data processing activity. So let's say now with employee and job candidate data subject to new privacy requirements, understand what's going on from the HR perspective, understand that, have those conversations and get clarity and have ongoing and continuous observability on data processing. Absolutely key for long-term sustainability and success.
Thank you, Leila. And Dan, we're thinking about that on your website, teachprivacy.com. Under the privacy training tab, there are more than 150 iterations of privacy training, which speaks to the complexity of the issue. How can someone know where to start to get a privacy training program off the ground related to that?
Well, I think to start, obviously just the general piece, why is it important? How do we understand what personal data is? And then what are some of the basic principles? And then beyond that, it really, starts with, the privacy program, understanding, what laws they're subject to, what employee groups are dealing with those particular laws and should be given training on those laws. So you need to train on those specific laws. Then there's specific topics that transcend particular laws, like data mapping, sensitive data that you find in a lot of different laws, data subject rights, and a variety of other things, all of which I think are very important and can be directed at the right groups that are really dealing with those particular issues or topics or involved with them. So that's sort of why I built my program the way I built it. It's a lot of different short pieces that can be used as needed. So if someone wants a general piece, there's a bunch of those, specific topics, specific laws. Privacy is such that it's very hard to kind of do just a quick and simple one size fits all because the landscape is so complicated and the laws differ so much from business to business depending on what things you're doing and what countries and states you're doing business in. And so as a result, it's a lot more complicated. With security training, which I also have, what's nice is, the advice for phishing is the advice for phishing. And, you can train someone on, passwords and phishing and some of the basic data security topics like social engineering and so on. And really, it's very consistent across the board. So it's a much easier task to some extent. I mean, getting people to listen to it is another challenge. But in terms of the content, what you put into it is very much, worldwide. It's the same. Privacy, what makes it so complicated is it's different. It's so different depending on kind of what you're doing and where you're doing business. So that's why privacy training is, I think, really is something that needs some thought. And also it's not something you can do in a day. I think that, when you're starting out, just getting training on the board and getting it done is great. That's a great starting point. As a program matures more, that's where it makes sense to start thinking about how do you address the different employee groups, and how do you deepen and add complexity to the training without overwhelming people, without confusing people. So that's always a balance, and that's one thing I believe in training is you need to train and think about the task at hand. And I think one thing that you had mentioned, Jeff, a lot of corporate training can readily be very boring. And one thing that I've found rather surprising and somewhat disappointing when I started this, and one of the things that made me do this was I was surprised at how corporate training was very bland and often not very effective pedagogically. It was just boring and just spit out information at people, but didn't really care to make it interesting or draw people in or educate people. And I really think, in a way, like maybe the word train. I mean, if I were, commander of the world, I would change the word training to education, because I mean that's really the goal. And I think the great things about education that we see in school, the things that you loved in school, the teachers that most engaged you, the things that most engaged you in school, you often don't find in corporate education. I mean, corporate training. So I think it's really important that the training be built in a way that really understands how people learn. I think keeping it short, keeping it fun, engaging, using some humor, mixing it up, so it's not that kind of bland sameness, because people do get all these trainings, especially at big companies, just thrown at them. And you can check the box and say, I told them these 200 things and did all this training for them in this day, but they're not really learning it.
Exactly.
And I think that's really the key. You really want people to learn enough, and you want to work backwards from what do you want them to do. What's your goal for this course? The goal is just check a box and say, I told them so. That's kind of worthless to me. I think the goal is really to get them to understand enough so that they care, and they basically know when to ask for help, and they know, critical things they need to do. And then work backwards. You train to make sure that those points are conveyed and that the goals are achieved.
Yeah. No, and I love the point about the phishing exercise, Daniel. And I think, to the extent that you can actually run a live phishing exercise where you send an email trying to actually, take information in the same way that you would experience as a phishing attack, and running that is a good way of also enforcing the training. And I've seen that done in a number of organizations, and it's very effective because it's, let's test what you've learned. So it's a real life practical way of ensuring that after someone has learned a particular topic, that we have this opportunity to ensure that in practice, if we are faced with a similar situation, we'll be handling it correctly. And I think similarly, as you run into what can be a lot of sticky privacy issues as you're building a program, especially as in-house counsel, and depending on the nature of your business, bringing those real life situations to light with the teams that you are collaborating with, talking to engineers about the challenges you're facing, talk about a strange data subject request that you might have received and how you had to navigate managing a solution to a really challenging problem, can also be a good way to enforce what is learned in that particular training.
Yeah, exactly. And I have a security background, so I'm often telling people that I feel like privacy right now is where security was in 2004. So security is very mature and things are very standardized. But with privacy, we've got all these different state laws. There's no federal law really. So until we get all of that sorted out, it's going to be hard to really make sure all of that is like a phishing exercise, right? Where it's just all straightforward. So great thoughts there. Leila, I wanted to ask you, how big should organizations be thinking about their privacy program? Should it be covering only those data privacy regulations pertinent to their organization, or should it broaden to address privacy laws in general? And I know we've talked about this a little bit, but I think how should companies be thinking about that?
Yeah, and it does come back to first principles, because I think even a U.S.-based company has likely got global ambitions. So setting your program up for entering into new jurisdictions, which will have particular requirements, like especially if you're looking at entering into the European market, or even China is another place where we have new developments in privacy laws, India as well. So really understanding and preparing your organization to enter in to any potential jurisdiction, I think is critical. And I think this always comes back down to having an understanding of what the business is doing and really grasping that effectively. Because once you have clarity and observability about what exactly is going on in your business, whether that's with respect to data flows, if you're a data processor or controller, or if it relates to different departments, if it's related to your sales team and how you're getting new prospective customers, or your marketing team, understanding what's going on in the business as in-house counsel is absolutely critical. And what's important is that you also create sort of a foundation. So the laws, I think, as Dan mentioned, are changing so quickly that it can feel like playing whack-a-mole when trying to keep up. And that's just not where you want to be when you're building out a global program. You want to have that foundational understanding, and you want to feel prepared. So I think in addition to having observability, including of legacy information, as well as what's coming down the pipeline, you have to get that under control. And then once you have that under control, if you are deciding to enter into a new market, finding the right local counsel for that particular jurisdiction, or someone who can help you and guide you with respect to that. And there are a lot of great publications, I think, through various firms that help you to get jurisdictionally aware. So educating yourself and getting, I'll use Dan's word, an education instead of training, but educating yourself, really ensuring that education is there. And then again, having that buy-in across the business that, listen, from the legal and privacy perspective, we need to be prepared. We need to have some understanding in advance. We can't just kind of go and enter a new market at the very last minute here. We have to have some level of notice that allows the privacy and legal teams to get that time to prepare, to update the privacy statement, to understand if there are any very specific laws. Like, for example, in China, you may have to host data specifically in China. So if there are any data localization requirements that you have to consider, and then considering those downstream consequences or impacts for other implications and other privacy laws that may be present, I think are all really key. But I always try to take it to first principles, because as you're entering into a new organization, it can be just so difficult to understand even which laws apply, and you will be surprised. That is, the only thing constant about privacy is that it's constantly changing. So surely there will be a moment that you didn't know that you might have been subject to another law. I mean, I want to say that I hope that never happens, but realistically, given we don't have a federal privacy law, when you kicked off the discussion, it was exactly on that point. Having a way to stay on top of everything developing across the country, it can be very challenging. So you have to have at least first principles in place, and that is about knowing your data, understanding exactly what you're doing to your data, how it's flowing, what are the processing activities involved, and what are the other groups across the organization that are involved in that processing, and those downstream implications. So beyond what's happening in-house, 70% of security incidents happen with your third-party vendors. So you really need to understand downstream which third parties are accessing your data. Absolutely critical priority, and making sure that it's not just about the paperwork in place, but actually understanding real-time flows to third parties, understanding when they have access to your data, what's actually done from that point forward. And these are some of the things that have been a focus for us.
Thank you, Leila. And Dan, I'm sure you have some thoughts on this particular topic as well.
Yeah, well, I don't have too much to add to what Leila has said. I mean, I think she said it very, very well. It is a very dynamic landscape. I think the key is having a good foundation really gets you very far. I mean, that's really essential, because at the core, the basic foundation of most privacy laws is similar. There are a lot of differences and a lot of details, but at the core, there are some basic foundations. Getting a handle on your data is key. Data mapping, that will help you no matter what law you're dealing with. So there's certain things that if you do some of the basic things that a privacy program should do, you are already well on your way. And then you can really start to focus on the intricacies of different laws and how you're going to do that. But you can't get anywhere without the foundation. But once you have the foundation, what's nice is that really grounds you in the most important things. And then you can go and tackle all the different laws. Even if the U.S. were to get a federal law, it might simplify things a little bit, but it's not going to simplify things a lot. You still have worldwide privacy laws. There's more than 150 comprehensive privacy laws around the world, and more. There are increasingly people think, oh, the EU is just the GDPR. Well, actually, no, it's not. There are a whole bunch of other laws that we're going to have to deal with. E-privacy, the Digital Services Act. There's a whole bunch of other laws that the EU is cooking up. They don't want to be left out in all the fun that's happening in the U.S. with all the state laws. So hey, let's create a whole bunch of other laws and requirements. So just you wait. There's going to be even more complexity out of Europe with a lot more than just one law. And then in the U.S., I think we're going to see more. And even if we do have a federal law, it doesn't get rid of HIPAA. It doesn't get rid of the TCPA. It doesn't get rid of a lot of other laws. So there will be complexity. And I think that's the one constant in privacy is that it's constantly changing. And I think that's going to be the case. So, you need to deal with it. And there isn't going to be, some grand law that's going to swoop in to make things easier. So, that's just an argument for one, build a good foundation, because that's really critical. And then, keep working at it and keep up with what's going on and try your best to navigate this landscape. And that's one thing too, when it comes to enforcement, you can reduce your risk by trying. Those that just throw up their hands and say, oh, it's so complicated, there's so many laws, I'm not going to care, I'm not going to do anything because I can't be perfect. That is a recipe for getting the regulators to really come down on you hard.
That's 100% right. Exactly. Don't let perfect be the enemy of the good.
Exactly. And also too, if you try, a lot of regulators will be more lenient versus if you show contempt for the law and you've totally ignored it. That's where they're more likely to, be more punitive. A lot of cases, don't, have an enforcement. The enforcement is only on a very small number of cases. If you look at that, and cases with big fines, or it's not a large number. You hear about them, but if you look at what's going on and all the instances of problems with compliance, it's a fraction. And so you want to be, you don't want to be in the bottom. You want to be trying. And I think if regulators see that you're trying in good faith and you miss something, they're more likely to be easier. Sometimes you might, they might say, fine, we're just going to warn you. Sometimes, not all the cases, but we're dealing with risk. So it's what are the odds? So I think making an effort, trying, the more you do and the more robust the privacy program is, the more likely the regulators are going to say, okay, we will, be a little more lenient in this case. There's never any guarantees, but I think that still it's well worth it to do this, because it will reduce those instances. And you want a good reputation among the regular. You want a reputation of trying to take these laws seriously, and it really makes, I think, a difference across the board, because with incidents, with problems. It's not just one regulator that companies have to answer to. Now it's many regulators around the world and around different states. So
100%.
a lot of folks looking at you. You want to look good when your curtain is pulled back.
That's it. And I'm making progress to get that understanding of what's generally going on with data processing and doing what you say and saying what you do, so there are no big surprises. I've also seen sort of the opposite with certain clients, where they got so wrapped around the axle of the nuances of which law applies and which doesn't, that they've lost sight of the first principles of privacy, of some of the things you mentioned, Dan. The observability piece, just generally making sure people are educated on privacy, understanding the data that you have, understanding who your third-party sub-processors are, and otherwise. So I completely agree that if you try too hard to understand the nuances of each and every individual law, you're going to lose sight of the whole point, which is, for in-house counsel with limited resources, you have to focus on the first principles of establishing a privacy program. That's what's key. And exactly to your point, Dan, doing something and trying to at least meet, for example, the OECD privacy principles that are laid out is much better than spending all your time just studying the nuances of the new draft regulations coming out of California. Get started. Don't wait until you have a perfect understanding of everything that's going on. I also love the analogy, Dan, of the foundation. This is always what we talk about at Relyance. And it's about building pillars atop that foundation. And the foundation is managing your data inventory and map. With that foundation, you can build all kinds of different pillars, your data protection assessments, making sure you're fulfilling DSARs, understanding and being able to present to your executive team around what you're doing with your privacy program. Of course, training needs to be related to what data you are going to be processing and what you're doing with it. So really appreciated you making that point as well, Dan.
Thanks, Leila. So I wanted to just wrap up with a final question, which is directed to Leila. So, how can privacy professionals, since you've been a former head of privacy before starting Relyance, how can they justify the cost of a privacy program and related, and I'll change the word, education?
Yeah, well, as a matter of fact, at the IAPP Summit in the spring, this is exactly the panel I'll be speaking on. So hopefully we will see some of the attendees there, because there's a lot to say on this. So I guess the quick TLDR version is that, especially in light of the downturn, this economic recession that we are facing, it is even more important to bring data-driven insights to the executive team to make sure that you have budget and can unlock that budget. Absolutely essential in order to move forward with your program. And we can't, privacy is sort of, it's non-optional. So we cannot just say that this is a nice to have during a recession. It is still a must have. The laws are not changing. They're only getting more strict. And so it's absolutely critical that even during this downturn, that privacy professionals are equipped with data-driven insights on why, as an organization's trust is the currency, and it's absolutely critical as part of that foundational trust with your buyers, with your users, with the public, with regulators, that you invest in ensuring that you can really get your arms around any changes to your program, any changes to data processing, and really understand what you're doing. And despite this downturn, I know that a lot of budgets are getting tighter at the moment, but it's going to be critical to continue to maintain that, because what's even more costly is losing control of your privacy program when trust is the currency we rely on.
Thank you. And Dan, any final thoughts, anything you want to add on to that?
Yeah, well, I definitely think that it's kind of a long-term thinking, and really getting the C-suite to understand that if you spend money now and invest it, and really as a percentage of the overall revenue and profit of a company, your privacy is not that big of a a chunk, and it's a fraction of what is spent on security. But it's very important because if there is an incident, if something goes wrong, and something will go wrong, it could be a data breach or something, a good privacy program can go a long way, and it affects the reputation among, for your customers, but also it affects the reputation that you have with regulators. If you have a really poor privacy program and did not invest well in it, that's going to reflect on the regulators. And if you have a lot of problems and incidents, your reputation with the regulators is going to be as a troublemaker. And they're going to know to kind of look in your way, and constantly be looking to see what you're doing now. And once you burn that reputation with the regulators, good luck down the road, because anytime there's something wrong, they're going to know that they're going to really come after you more aggressively. So it's definitely going to save a lot of money in the long run in terms of the cost and pain of dealing with patching up if something does go wrong. So it's kind of insurance policy to make sure that that when something happens, which inevitably a breach happens, and when folks look at the breach, they're going to look at other things too. They look broadly, and if they see all sorts of other things going on, that creates more fines and more scrutiny. So it's really important, I think, to have a good program and avoid these problems. You build a good reputation, because once it's ruined, it's really hard to just get it back, to get back trust, to get back a good reputation. If you do these foundational things too, it's good when the next law comes out, because then it's not a freak out situation when a new state passes a law, there's a new requirement in a different country. It's much, much easier to be able to do things if you have a strong program. If you don't have a strong program, then, if something happens, you really could be caught off guard, and it could be an utter nightmare. So I think just being prepared kind of helps you, navigate the future as things go on. So I think it's a kind of a long-term thinking, but it's important to think, not just what's going to happen in the next 6 months, but to think long term. What is the best thing to make the company healthy for the future, and able to address changes that will happen, able to deal with incidents or anything that could go wrong. I think then if you're a long term thinker, having a program, more than pays for itself. And I think that, privacy program, I think is wrongfully thought as a cost center. It's not. I mean, a privacy program really can help various groups in a company build in ways that are not going to run into problems down the road. And if you build responsibly and thoughtfully, then you don't have to. It's much, much harder to kind of go back and patch up and try to clean up and rebuild something because you built it wrong, and now it's going to be you're going to have to do something to comply with laws. It's much better to do it in the beginning, because a lot of that cost, expense, and hassle could have been saved. And you can still achieve the same goals. And it's much easier to try to figure out how do you achieve your goals without violating the law, without violating privacy, than to try to do it, looking in reverse. And so I think it's better to do it proactively. And it's better to ensure that you'll get to the place where you want to go, but ultimately be able to do it in a much more thoughtful and strategic way.
Yeah, completely agreed. So I think we definitely have covered a couple of foundational pieces of privacy today, which is always look at first principles. The only constant in privacy is constant change. Those are two of the things I think we can take away from this. So thank you everyone for joining us. Please visit us at Relyance.ai. That's RELYANCE.ai. You can also email us at info@Relyance.ai, and you can reach Dan at teachprivacy.com. So thank you so much for your time today, and we look forward to seeing you at future webinars.
Thanks, Jeff. Thanks, Dan.
Thank you.